using a microphone is because I clear my throat a lot. It's very annoying for the microphone, but I'll try to keep it down. As I was just saying, because I'm a practitioner, I'm not an academic. I don't want to go academic, so for this course, I try to be as simple, as practicable, also as fun and interesting for you. Just so you know, I'm not married and I'm not divorced. So I'm only experienced in the legal practice, not with my own experience. But I would indeed really appreciate it if you can bring in the class with your own experience, not necessarily your experience of divorce, but perhaps your observations, experiences from your family and friends, and also your thoughts in general. I think it's very beneficial if you can reflect on these things in learning family law, because only then it makes sense to you. I know that you get your course material today is the orange book you have, and as I understand, you don't have a textbook, and that's the only course material you get, right? It covers the ground, the basics, but it's only the basics. So from time to time, when we discuss some topics, especially on children and finance, I might ask you to look into some legislations, the key legislations only, and some key cases. By key, I mean just one or two beforehand, just to supplement the course materials, the course manual, because they're absolutely essential. I will do my best to prepare and provide the slides to you beforehand, so you know what I intend to cover in the forthcoming lectures. I think you should now have 3 sets of slides. That's for today, Friday, and next Monday. Usually I would prefer to do it, I would do 2 slides a week ahead, so you would have the weekend to read if you want. The reason why I give you 3 is because I'm in court the entire week. I don't have time to prepare for next Monday. That's why you have the 3rd lecture beforehand. And also you will see in my slides sometimes there will be cases. But don't worry too much about reading the cases beforehand. They are mostly for illustration purposes, so you get to understand the concepts better. For the legislation, sometimes I will summarize it, but sometimes I would prefer to have extracts of legislative texts instead of just summarized legal points. The reason is this. I want to be accurate and complete. I don't want to mislead you as to the law. And I also think that unlike other legislation, such as in maybe probate, in testator rules, it's quite straightforward. The legislation in the family domain can be very convoluted and confusing. And I think it was beneficial if sometimes I can take you through some legislation, so you get used to construction of legislation and also analysis of ordinances. For the course materials, you will have the slides beforehand. So it's always better if you come prepared and read before. So you have the opportunity to reflect and ask questions, and then we can have a meaningful discussions in class. But if you don't have the time, I appreciate that you might have work and other commitments. That's also fine. But I would tell you beforehand what I would do next. But also with the slides, just try to skim through the chapters maybe, so you have some basic ideas and frameworks as to what we'll be doing. So what I want to achieve with my lecture is, instead of just reciting your course manuals chapter by chapter, I want to draw your attention to the main point to help you better understand things that you might not be able to understand from reading alone. Do you have the course, the schedule with you? If not, I can put it up here. Because I didn't prepare a course outline, so I just want to let you know. For today, as you will see from the slides, I plan to do marriage, nullity, separation and maintenance orders. That will be chapter 1 to 3 in your course manual. It is a lot. we might not have the time to do separation and maintenance order. In which case, then we can do it later in lecture, I think 9. That's what I plan for revision. We can do it later. It's fine. The reason why we're doing a lot today is this. Nullity, well, we will do marriage first and then nullity. Nullity is really rare in practice, but separation maintenance order is pretty much unheard of in practice. It exists, it is available in law, but I've never seen or heard of anyone actually making such an application. So I think because it's in your manual, so I want you to know that it exists, but I don't think it's that important. For Friday, we'll be doing main suit, that's the divorce itself, and that would be pretty much Chapter 5 and Chapter 6. Chapter 5 is the substantive law, and Chapter 6 is more on the procedure. So if you can, for Friday, if you have the time tomorrow or during daytime on Friday, you can read Chapter 5, especially on the sole ground of divorce and the 5 facts. I think that would be good enough for the next class. It's very straightforward. But as I said, if you don't have the time, it's fine. You don't have to read it beforehand. So for the first week of this course module, we would have already covered a marriage and how you would exit a relationship of marriage. For the forthcoming 6 lectures, we'll be doing children and finance. Because they're really important. That's why we're spending so much time on children and finance, even though there are only 2 chapters in your reading. And because of the way that I plan it, you will have less reading, especially leading towards your Christmas and New Year's. So I hope we can be more detailed and more focused. And I invite your participation in this process and discussions in our lecture. So we'll do children first. That's the third set of slides you have. Okay, fine. So that's December 13, next Monday. And then Friday, we're doing children as well. For the 20th of December, we'll be doing domestic violence and abduction. So starting the 22nd of December, and then 29th, and then the 3rd of January, we'll be doing finance. January the 5th, it's on alternative dispute resolution. It's pretty relaxed. There isn't much reading, and then it's not difficult anyway. For our last lecture on the 10th of January, I haven't really set what we're doing on that last class. We might use that to cover things that we're not able to cover in the previous lectures. My preliminary plan is to go through the material in a global view, so then you have a fresh memory as to what we would have done by then. The 4th of April is meant for a revision session. So I think we'll be doing the past papers for that lecture. So before the April class, you can attempt the past papers. I think you would have your revision manual by then. I think there are 3 sets of past paper that you can try, and then we can discuss that on the 4th of April. Okay? Does it sound good to you? The assignment. Well, I can tell you now. I think you have your assignment on your on Soul already. The assignment is on the main suit. It's on what we'll be doing on Friday. But it's really easy. Don't get stressed out. It really is easy, so you won't fail. The main question is on children. So by the time we finish the class on the 20th of December, you would be able to, well, if you pay attention to my lectures, you would be able to get a merits level kind of grade. If you want to achieve excellence, then you might need to know a little bit about finance. But putting myself in your shoes, it might be difficult because you're not in practice, so you might not have that global view in understanding that whole factual scenario. So in other words, you won't be punished by mark deduction if you don't cover any finance. My requirement is simply that you look at the situation realistically and from a practical point of view. That's what I want. But of course, you have to cover the basic concepts. That's for you to pass the assignment. To me, it's relatively easy. I don't see anyone fail. I actually think that you would achieve quite a good mark. But if you want to get the excellent, then you would have to be really practical and comprehensive. Let me just fix this. Okay. Is that okay? Does that answer your question? So the main bulk of the lectures is on children and finance. The first reason is because that's where the main disputes are when you are doing actual litigation. The second reason for your purpose is that I have looked into your past papers. What it consists is part 1, where there were 5 questions, and you have a choice to answer 3 of them. 3 out of 5. So each question is 20 mark. These questions, let me just fix it. These questions, again, include children and finance. They can include other topics. For the second part, which is just 1 question you don't get to choose, sometimes you get to choose, but it's 40 marks. So it carries a lot of weight, and it's either a children question or it can be a finance question. So even for your exam purpose, children and finance are important, even if you don't care about practice. Okay. Do we have any questions on the administrative staff? About work. Okay. I know it is working. Is it working? I can't hear it. Okay, anyways. Should we start the lecture of today, finally? Well, in Hong Kong these days, marriage is defined as a voluntary union for life of one man with one woman to the exclusion of all others. That is the requirement set out under Section 4 of the Marriage Reform Ordinance. For such a marriage to be a valid marriage as recognized in Hong Kong law, it would also need to satisfy certain requirements under the Marriage Ordinance, which we will talk about later. So for the purpose of discussing a valid marriage and also nullity, the main ordinances would be the Marriage Reform Ordinance and the Marriage Ordinance. They have to be read together. And from this definition, you would know that marriage is a union between a man and a woman. So as of now, gay marriage is illegal in Hong Kong. It is not being recognized. And also, legally, you can only have 2 persons in a marriage. You can't lawfully have a third wheel or mistress. You would note, which is in red here, in the ordinance, that there is this provision of the appointed day, which is the 7th of October 1971. So why do we have this date specifically? To give you some background, the Marriage Ordinance was enacted in 1875. So that's shortly after the Great Britain took over the governance of Hong Kong. So essentially, at the time, they were trying to import English law into Hong Kong. So I think the idea is such that the English people who are living in Hong Kong would be regulating their lives under the same set of law as English law, and also they're able to conduct the same type of life as they're in England. So under this big grand scheme of importing the English law to Hong Kong, the Marriage Ordinance was enacted to ensure that all Christian marriages was registered in one system. But as you can imagine, back in 1875, there probably weren't many local Chinese who were Christian and who would celebrate their marriages in a Christian way. They're likely to stick to the traditional Chinese marriage, as in the local culture. So what happened with that system back then is that if you are a Christian and then you get married in a Christian way, they're in the system. But if you are Chinese, you're not Christians, you get married in your own way, but they're not in the system. So they're legal in the sense that they're still allowed by the English law. They're not touched upon by English people. But they're illegal in the sense that they're not officially on the record in the system. So you would have these two types of, well, vastly two types of marriages, the Christian English marriages and traditional Chinese marriages running in parallel in their separate streams. So in 1970, on the 10th of July, the Marriage Reform Ordinance was enacted. The purpose is to make provision with regard to customary marriages, concubinage, modern marriages, and dissolution of marriages, and for connected purposes. And the Marriage Reform Ordinance provides for such an appointed day in Section 2. The provision of the Marriage Reform Ordinance and also the appointed day is basically to fill the lacuna in legislation and to recognize traditional Chinese marriages as valid legal marriages in Hong Kong. I don't know why it was specifically on the 7th of October 1971. The ordinance was enacted in 1970. I don't know why that day, but that's what is provided for. That day is a watershed. What it means is that if you entered into a marriage in Hong Kong on or after that appointed day, then it has to be a voluntary union for life of one man with one woman to the exclusion of all others. But for marriages before the appointed day, such as traditional Chinese customary marriages, if it was celebrated in accordance with the relevant rules as provided under the Marriage Reform Ordinance, then it can also be recognized as valid if it was celebrated before the appointed day. So what this ordinance, the Marriage Reform Ordinance, does is to bridge the gap for marriages in the past and to consolidate, to unify the two streams of marriage. So you have all the legal marriages in one system, in one registry. Okay, that's a very rough overview of the history of these legislations. So before 1971, the 7th of October, the appointed day, there are 4 categories of conventional local marriages in Chinese culture. Namely, you have the Chinese customary marriages, Chinese modern marriages, king piu, and concubinage. So each of these 4 types of traditional marriages is addressed and dealt with separately and specifically in the Marriage Reform Ordinance in terms of their validity in different points of time. So we have to look at them individually. Are we all right so far? Sorry, the first part is a little bit historical. I promise it's the only time we'll talk about history, and they're not really that significant in practice. Okay, and customary marriages, they refer to marriages which were celebrated in accordance with traditions, customs, rites, and ceremonies. They're derived from local Chinese customs and Qing dynasty law. You should note that for a customary marriage under Qing law, you can't take secondary wives when you have a principal wife. So basically, you can only have one wife at a time under Qing law. So the wife you get is always called in Chinese a cai, The first principal wife you get is called Gitfa. So that's your first principal wife. So if that wife dies, or for some reason you end the union of this couple, such as by perhaps Yao Cai, then you can take on a secondary wife. But that wife, it's also called Cai, but it's not a Gitfa. It's called King Fong. Okay. That's about all the Chinese I know. Traditional Chinese customs included the 3 covenants and 6 rites. Sounds sort of like, that's how I read it. I know. Usually family law is not like that. So according to your course manual, for the purposes of establishing the existence of a Chinese customary marriage, only the following 3 of the 6 rites were actually important, which I set out here, namely the betrothal through a go-between, and the physical delivery of the bride, and also the acceptance of the bride in the groom's family home. I assume you can all imagine that if you watch some sort of television. Just a rough idea. I don't know any of these things. I don't exist at that point of time. So I really don't know. And as you would expect in the modern context, you would expect Chinese customs vary from space to space, from clan to clan, and also from time to time. So when you decide whether there is a valid customary marriage, very likely you will need to rely on expert opinion on traditional Chinese customs relating to marriages. Sorry, is it going too fast? Is it okay? In accordance with Section 7 of the MRO, a customary marriage is valid if it is celebrated in Hong Kong and before the appointed day and in accordance with Chinese law and custom. So the first bullet point, these are the legal requirements. They are set out in subsection 1 of Section 7. Chinese law and custom is defined in Section 2 of the same ordinance. It says, it means such of the laws and customs of China as would immediately prior to the 5th of April 1843 have been applicable to Chinese inhabitants of Hong Kong. It's in the ordinance, I didn't put it here. But it is very broad and very vague. It's not very useful. It's just a law that is applicable immediately prior to the 5th of April 1843. Doesn't really mean anything. So to help you, there is a deeming section in Section 7, subsection 2. That's the fourth, the small bullet point, number 4. So we read, a marriage shall be deemed to accord with Chinese law and custom. That's the third requirement. If it was accepted or is celebrated before the appointed day in Hong Kong, in accordance with the traditional Chinese customs accepted at the time of the marriage, as appropriate for the celebration of marriage. Sorry, I think there's a typo. For the celebration of marriage, either in the part of Hong Kong where the marriage took place, or in the place recognized by the family of either party to the marriage as their family place of origin. That's one of the examples of legislation reading I want to set out here to help you construct and analyze what it means. It is very long, so we need to break it down. So for the third requirement, there is a deeming provision in subsection 2. So that's the third requirement. Don't think this is very useful with most. So this is the third requirement. You have the definition in section 2, but still you don't know what it means. And that's why you have subsection 2 for the deeming provision. It is very long. What it means is that the third requirement is satisfied if the marriage, A marriage shall be deemed to accord with Chinese law and custom if the marriage is celebrated before the appointed day and in Hong Kong, and according to the Chinese customs that are appropriate for the purpose of celebrating marriages, and the customs which are accepted at the time of marriage, as in the part of Hong Kong where the marriage took place. Or the second alternative you have is if the customs appropriate for the celebration of marriages at the time of marriage was accepted as in the place recognized by family of either party as their family place of origin. If I can give you an example, let's say that before the appointed day in Hong Kong, there's a marriage, there's a customary marriage in, say, Yuen Long. It is a valid customary marriage if it is in accordance with the marriage-related custom accepted in Yuen Long. That's the Lim 1 in the part of Hong Kong where the marriage took place. Or it is deemed to be accord with Chinese law and customs if, for instance, the wife's family is from Chiu Chao, and if you celebrate that marriage in Yuen Long, in according to the customs as accepted in Chiu Chao culture. Does it make sense? Because when you go to the Ordinance of subsection 2, it's very, very long. You don't know how to read the sentence. That's why I try to break it down for you. Is it clear for you? Do you kind of understand what it means? Okay, I'll repeat it one more time. So for a customary marriage, if you, for it to be valid, there are 3 requirements. It has to be celebrated in Hong Kong. It has to be before the appointed day. It has to accord with Chinese law and custom. These are the requirements. We don't know what Chinese law and custom means. In the Ordinance, there is an explanation. It is defined in section 2. You can go back and read section 2, the relevant provision, but it's not very helpful because the wording is really broad. And that's why in the same section, section 7, subsection 2, there is a deeming section saying that the marriage is deemed to be in accordance with Chinese law and custom. That's the 3rd requirement. If it is celebrated before the day in Hong Kong, in accordance with the traditional Chinese customs appropriate for marriage that were accepted at the time when you get married in the part of Hong Kong where the marriage took place. If you get married in Yuen Long and that custom, the customs is accepted as in Yuen Long, then it's valid. It's deemed to accord with Chinese law and custom. Or alternatively, if you have that marriage in Yuen Long, if it's not in accordance with the customs in Yuen Long, but if your family originates from a place, the examples I gave is Qingdao, then if you celebrate that marriage in accordance with the customs in Qingdao culture, then it's also valid. Does it kind of make sense to you? So there are 3 options. For you to satisfy the 3rd requirement, there are 3 options. The first way you can go is to rely on the section 7 definition. And it's very difficult to satisfy because it's very broad. The 2 other options are easier, as in subsection 2, because they narrows down the scope of custom. But again, even if you narrow it down, it has practical problems. There isn't a set of universal rules for traditional Chinese customs. The statutory definition and the deeming provisions, they're not fully useful. So it is very likely you would need to resort to expert opinion. The problem with expert opinion on Chinese customs is that is Chinese customs really an area of expertise? Because we can't have one set of, we don't have an agreed set of customs that we all see as customs. It varies from place to place, from time to time. And also, do we still have people who allegedly know these customs that are still living these days? You probably can't find such an expert. And what makes them an expert anyway? If this area of customs is not recognized as a type of specialization. So these are the practical issues that would arise with this requirement of in accordance with Chinese law and custom. But don't worry about it, there aren't many cases on customary marriage these days. But it's something that you might want to think about if you're interested. Okay. Are we all clear on customary marriage? Then I can move on. Now, under section 2, a marriage celebrated in Hong Kong before the appointed day by open ceremony as a modern marriage and in the presence of 2 or more witnesses. That's what a Chinese modern marriage means. So you have the requirements that it has to be celebrated in Hong Kong. It has to be before the appointed day, the 7th of October, 1971. It has to be by open ceremony, and it has to be witnessed by 2 persons at least. The emphasis of Chinese modern marriage is the marriage being open. What it means is simply that for a reasonable man, whether he would think that a ceremony of marriage had taken place. So if there are 2 people getting married, do I think that they're getting married? That's what it means. That's what it means by open. Whether a third party, a reasonable man, would understand it as a marriage having taken place. As you would read from your course manual, the Chinese modern marriage is a product of the Civil Code 1930 of the Republic of China, which provides for monogamous marriage and that the marriage has to be celebrated as an open ceremony and in the presence of 2 or more witnesses. For a Chinese modern marriage to be valid, apart from the above requirement of that being an open ceremony, under Section 8, there is also the requirement of monogamy with 1 man and 1 woman without a third party or a second wife, and it cannot be a gay marriage. I've underlined these parts in the legislation. And also the husband and the wife at the time of marriage, they have to be at least 16 years old, and they were not married to another person at the time. So if all these requirements are satisfied, a modern marriage is deemed to have been valid since the time of celebration under Section 8. Now, if you would note, pay attention to subsection B, that the marriage was, the modern marriage is valid even if the marriage is not in accordance with the marriage ordinance. So the requirement is that it has to be celebrated in Hong Kong, it has to be before the appointed day, it has to be an open ceremony, open meaning that a reasonable man think that a marriage has taken place, and it has to be in the presence of 2 or more witnesses. It has to be between a man and a woman, not a gay marriage. You both have to be at least 16 years old, and you're not married to any other person. Okay, simple as that. For customary marriage and Chinese modern marriages, if they took place before the appointed day, they can be registered register a customary marriage or a Chinese modern marriage is either by consent in writing of the other of the other party to the marriages. So if both of you in writing put your consent, or if the other party doesn't give consent, you can apply straight to the court at the district court for a declaration for the existence of such a valid customary marriage or a valid modern marriage. Registration is not mandatory, and if you don't register the marriage, it doesn't mean that it's void. But if you want, sometimes you will want to validate the marriage because you need the necessary status in inheritance, in successions. And also, if you separate, you will want to get the relevant release under matrimonial rules. And that's why you would have the incentive to register. If you don't register, it's fine. But if you want these reliefs and awards available under the law, then you will need to register to declare your status with a valid marriage. So you see why the other party might be reluctant in giving consent. They don't want to give you the money if you get divorced. Okay? And you would note at this point, you should know already that registration and validation is only available for customary marriage and Chinese modern marriages. It is not available for King Tu or concubinage. The reason is simply, you will realize this in the end, it's because, well, for now, a marriage is union between a man and a wife. There's no third party. But under King Tu and concubinage, there's a third party. The law doesn't want to recognize that. I think that's the reason. Okay. So for a King Tu, it is a marriage of one man to two women, where one marriage is for his own father and the other for his father's brother, his uncle, to continue the male line of descent from his own father and from his uncle who has no son of his own. It is kind of like a concept of, in Chinese, 活该. Do you kind of know what it means, 活该? So basically, if you have your father's brother, your uncle. If your uncle doesn't have a son, then you can marry your first wife, and then you pass down the line for the trench of your father. Your uncle doesn't have a son, and then you'll be treated as the son of your uncle, and then you marry your second wife for the purpose to pass down the male line for the trench of your uncle. So if you have a son with your first wife, then the grandfather is your own father. The grandfather of the son is your own biological father. There's no problem with that son inheriting the estate through the trench of your father. If you have a son with your second wife, then the son will be treated as the grandson of your uncle, not of your father, even though your father is the biological grandfather. And then the second son with the second wife would inherit the estate, the legacy, through the trench of your uncle, not through your own father. It's very strange. It's quite foreign for me. I've never heard of a real case in my real life. And because your two wives, you're marrying your first wife for your father's line, you're marrying your second wife for your uncle's line. The two wives enjoy equal status. The second wife is not a mistress. It's not secondary to the first wife. They're both principal wives, but under two trenches of lines. So under Section 6 of the MRO, on or after the appointed day, no person shall contract a King Tu marriage, meaning that effectively King Tu is abolished by the MRO. The cutoff day is the appointed day, the 7th of October 1971. Under subsection 2, if a King Tu was entered before the appointed day, it was fine. It is valid. And the rights of children born to those parties to a kin-to marriage would not be affected, even if the child or the children were born after the appointed date. So the crucial date is whether the marriage took place before the appointed date. Okay, does it make sense? Is it okay? I see people frowning. You can't have a kin-to on or after the appointed day. End of story. If it's before the appointed day, it's fine. For the children, whether they enjoy the same rights, it depends on whether the children's parents enter into the marriage before that day. So even if the children are born after, then if the kin-to marriage is valid, has taken place before the appointed day, then the rights of the children are not affected. Okay. The fourth type of valid marriages before the appointed day is concubinage. It is different from a kin-to. It is an ancient arrangement whereby a man can take a number of women into his household. A concubinage is not a concubine. It's not exactly a mistress. Basically, there are second wives. The second wife, unlike a kin-to, would enjoy the status of secondary wife. They have a lower status than the principal wife. The principal wife is called cai or hifa cai. And the secondary wife is called qi. So it's something you would probably have watched from some TVB drama, when you see a big rich family and a man with many, many wives. And that's a concubinage. That's different from kin-to. A concubinage is valid before the appointed day. So on or after the appointed day, you cannot contract a concubinage as a form of valid marriage. But if you acquire the status of concubine before the day, you will still be recognized as a lawful concubine, and your children will continue to enjoy the same rights, even if they're born after the day. So again, the crucial date is when the marriage itself is contracted, not exactly when the children are born. So now you will see the pattern that after the appointed day, you cannot have a newly contracted kin-to or concubinage. So as I said, that's because the law no longer recognizes a marriage for a man with multiple wives. So even if the kin-to and concubinage that took place before the appointed day, that they're not affected, you can't register these marriages. The law doesn't want to see it in its registry. It won't show in the record. And of course, after the appointed day, you can't have a customary marriage or modern marriage either. But at least you will be able to register the marriages, and you can validate those marriages. Okay. So these are the situations with marriages before the appointed day. These are ancient history, not very important. On or after the appointed day, to be legally married, firstly you have to be single at the time of marriage. That's Section 4 of the MRO. So under Section 4, a marriage on or after the appointed day has to be monogamous. You can't be married to a wife already. So remember, it's a voluntary union for life of a man with a woman to the exclusion of all others. That's the definition under Section 4. Kin-to and concubinage, where a man 45 of the Offences Against the Person Ordinance, and you are subject to criminal liability and a maximum of 7 years in prison. The second requirement for a legal marriage in the modern day is that the marriage has to be between a man and a woman. So meaning that you can't have a gay marriage. From time to time, you will see cases relating to homosexual rights in the news. So for instance, in the case of Leung and Secretary for the Civil Service and others, Mr. Leung is an employee of the government. It was held in that case that his same-sex partner is entitled to receive spousal benefits, including medical and dental benefits. So that case recognized the right for same-sex couple to file tax returns for joint assessment as if they are a couple. So even though gay marriage is not legal in Hong Kong, there is also the right to deal with funeral matters by same-sex partners. This is the case of Lee Yik Ho. You might have heard of a case of QT, which concerns the right of same-sex couple to be granted dependent visa as a spouse. These are all judicial review cases, and they are successful on technical grounds, on constitutional grounds, but it doesn't change the law as of now in Hong Kong that homosexual marriage is not recognized. Okay? The third requirement is that each party has to be at least 16 years old. If you're not yet 16 years old, if any of the parties is not 16 years old, you won't get issued a marriage certificate. That's the requirement of Section 13 of the Marriage Ordinance. But that's not the Marriage Reform Ordinance, that's the Marriage Ordinance. And under Section 27 of the Marriage Ordinance, a marriage is null and void if at the time of its celebration, any party is under 16. So you have to be at least 16. But even if you're over 16, if you're under 21, and you're not a widow or widower, you will need written consent from the relevant persons as specified under statute. These people are usually just your parent or guardian. You will need consent to get married, well, if you're under 21. Under Section 29, this is just to supplement, they're not in the slides. If you are marrying under 21 without consent, it is an offense. It is a criminal offense. If you have knowledge of the requirement of getting consent, but you do not obtain the consent and you go ahead and get married, you would attract criminal liability. And any person who assists or procures such a marriage without consent would also catch criminal liability. The maximum punishment is a fine at level 5, which is 50,000 Hong Kong dollars, the maximum fine, and liability for imprisonment of up to 2 years. This is just so you know, it is a criminal offense if you don't comply with this requirement. And any assisting parties would also attract criminal liability onto themselves. But I don't see any of you under 21. I think it's all fine. Okay, the fourth requirement is that the parties to a marriage cannot be within the prohibited degrees of relationship by kindred and affinity. That's Section 27 of the Marriage Ordinance. So basically, it disallows what we call in Chinese 亂倫. Okay. Under Section 27 of this ordinance, a marriage is null and void. Sorry, did I get it wrong? A marriage is null and void on the ground of kindred and affinity. The list of that relationship can be found in Schedule 5 of Marriage Ordinance. I put an example here. It is just one part of it. There are other lists as well. So in this list, in Part 2, a marriage solemnized between a man on the left with any of these persons in the first column of Part 2 will be null and void. And a marriage between any woman and any of these persons with that woman would also be null and void. So for a man, you can't marry your mother, you can't marry your adoptive mother, can't marry your daughter or adopted daughter. You can't marry your grandparents. Your grandmother, sorry. Well, obviously can't marry your grandfather either. Can't marry your son's daughter, your grandchildren. Can't marry your sister. Can't marry your aunts and your nieces. So you have a sense of that close degree of relationship by kindred and affinity. There is also prohibition by virtue of degree of affinity from former marriages. So you have to pay attention to that. If you're interested, go into Schedule 5. They refer to relevant sections, and then you can read it together with Section 5. Okay. Last requirement is that the marriage has to be voluntary. The parties have to voluntarily contract to enter into the marriage. That's the requirement of Section 4 under the Marriage Reform Ordinance. Because a marriage is a voluntary union between a husband and wife. So there should not be any duress or mistake or any unsound mind which would render the marriage involuntary. And we will talk about this in greater length when we talk about normality. Okay. So apart from these 5 basic requirements, there are also formalities that you have to observe for a valid marriage. I think most of you should know that in Hong Kong, there are three ways for you to get married. It can either take place at a marriage registry, and then you can get married before a registrar, an officer, or it can take place in a licensed place of worship by a competent minister, such as in a church, or it can be at any other place in Hong Kong by a civil celebrant of marriages. That's what you would have when you see people have a lawyer, a civil celebrant in their wedding banquet or cocktail. You can do it at your wedding, the banquet. You can do it at a firm. I've seen people do that. Or it can be any places in Hong Kong, as long as you're allowed in that place. So obviously you won't get married in a prison. Okay. Other formalities. If you want to get married, you have to file a notice of intended marriage to the Registrar of Marriages in the prescribed form of Form 1 of Schedule 1 of the Marriage Ordinance. Let's take a look. How many of you are not married? So I have to show it to you. Okay, good. I'm not married either. I can take a look. Okay. So you would have the bridegroom and the bride, and you have the name, marital status, occupation, date of birth, residence, consent, Hong Kong ID address, name of the parents, telephone numbers. That's Form 1 of Schedule 1. Why is it in Chinese? Okay. You can find it in the Ordinance.
You can submit this form directly to the Registrar of Marriages, or you can do it through a civil celebrant, if you opt to get married through a civil celebrant. And then the registrar would exhibit part 1 of this form, which is just your basic information without disclosing your ID, your contacts, and your parents' name to the public for 15 days for anybody to inspect it. And after that 15 days has lapsed, the registrar would issue a certificate of registrar of marriage in Form 2. So this is basically what you have written in Form 1. But it's basically the registrar giving you the go-ahead to get married. Okay, and you have to note that there is a 3-month limit. You have to get married within that 3 months from the date of notice given. If the marriage does not take place within 3 months after giving that notice, then the notice will expire. It will be void, and then you have to issue a fresh notice before marriage can take place. So what it implies practically is this. In Hong Kong, you can't get married on an impulse. You have to wait for at least 15 days because there's this 15 days for inspection. And if you have a desired date of marriage, and it so happens to be a popular day, some people want to get married on Valentine's Day. So the first day you get to fight for that spot of appointment is 3 months before. Okay. That's the earliest day you can try and secure that date of marriage as you desire. For foreign marriages, you have a more comprehensive section in your course manual, and you can read it in your own time. Briefly, a foreign marriage is recognized as valid marriage in Hong Kong if the parties have the legal capacity to marriage, meaning that each of the parties is at least 16 years old. They're not within the prohibited degrees of relationship by affinity or kindred, and they're not a party to an existing marriage. And I should add here that they are not of the same sex. It has to be a man and a woman. They both have to give consent to marriage, obviously, because it has to be a voluntary union. And the marriage ceremony followed the legal procedures recognized by the laws in force at the time and at the place where the marriage is performed. So if you want to get married in Las Vegas, for instance, the ceremony has to be recognized as legal, as in the law in Las Vegas. So you do it that way properly, and then you satisfy all the other requirements here as required under Hong Kong law, and plus not a gay marriage. The reason why we need to know the validity of marriage in the eyes of Hong Kong law, the validity of foreign marriage in the eyes of Hong Kong law is this. If you want to get married in Hong Kong, it doesn't really matter where you get married, as long as the marriage is seen as valid in Hong Kong law. So you can get married even if you can get divorced even if you're married overseas. It doesn't matter. And in fact, we see a lot of marriages that took place in mainland China or even overseas. If there's any issue with a marriage validity, then the way is to consider nullity. Does it make sense to you? So if it's a valid marriage, valid at the time of celebration in the place where the marriage took place, then you can get a divorce. But if for some reason the marriage is not valid, then you will have to consider nullity. You can't get a divorce. And then we're here for nullity. Now, because it's the second part of 3 parts of lectures, do you want to take a break already? Is it too much of history? Or you want to continue for a little bit? Leave it to you to decide. Okay. Now, for the rest of this module, this course, we'll be focusing on divorce in Hong Kong and the relevant procedures of divorce. Nullity, as I've said earlier, when we began, it is really rare in practice. If you're a lawyer, you would probably encounter 1 case of nullity out of perhaps 1,000, if you ever encounter once. But I think for completeness, you should be alert to the existence of nullity and the basic requirements for a petition to nullity. Petition for nullity is an alternative to petition for divorce. The effect of getting nullity is to declare that the marriage is now void. It doesn't exist. Annulment can take the form of a void marriage or avoidable marriage. And whether a marriage is void or voidable, it would depend on the ground you rely on in your petition for nullity. For a void marriage, void means void ab initio. It is void at the beginning. There was never ever a valid marriage. It is a little artificial because you would have endured a relationship which you think is a marriage. But then in law, when you get a null marriage, the law sees it as it never exists. So the decree of nullity is merely a declaration saying that it is null and void. A marriage is void if there are a few situations. A marriage is void if the parties are within the prohibited degrees of kindred or affinity, or if either of the parties is under the age of 16, or the parties have intermarried in disregard of certain requirements as to the formality of marriage. What it means by in disregard of certain requirements is that, for instance, the marriage is not celebrated by a registrar in the office of the registrar, or a competent minister in a licensed place of worship, or an authorized civil celebrant. So remember, we talk about there are 3 ways to get married. So if none of it is satisfied, then the marriage is in disregard of that requirement as to formality and will be void ab initio. It can also include the situation that a marriage is celebrated under a false name, a false identification. Also, if there is no certificate of the registrar being issued or a special license in respect of the marriage, and both parties knowingly and willfully acquiesce in its celebration in such circumstances in the absence of a certificate of the registrar, it is also seen as you have failed to observe the requirement as to formality of marriage, and the marriage is also void. A marriage is void, or the marriage is otherwise invalid under the laws of Hong Kong. What it refers to is, for instance, if you have a concubinage, a kimtu, or a customary marriage or modern marriage after the appointed day, then the marriage is also void and null. And then you will also have void if at the time of the marriage either party was already lawfully married or the parties are not respectively male or female. Now for the last situation, you should know a case of W and the Registrar of Marriages. Have you done constitutional law yet? Or basic law? You should have known this case from that class. What happened is that it upheld the right of transgender people to get married as their affirmed gender, rather their assigned gender. So if you're a man and then you get procedure and then you turn into a woman, you're free to marry a man. Okay? For transgender situation. But these are all the requirements we have gone through with validity of a modern marriage, except the requirement of voluntariness. If a marriage falls short of any of these requirements, then the law sees the marriage as null and void. It's never existed. For avoidable marriage, it means that the marriage exists until a decree of nullity has been made absolute. It is treated as a valid marriage, but there are certain factors that would give you the right, the choice to end the legal relationship. It is different from a void marriage because for a void marriage, simply if you fail to observe those requirements, then it is void. The decree from the court is just a declaration. It doesn't change the fact that it's null and void from the very beginning. But for avoidable marriage, you can pretend that it is a valid marriage. The presence of these, what I would call vitiating factors, is that it gives you the choice to end the marriage by petition for nullity. So if you exercise that option, the marriage exists until you have a decree of nullity. But if you don't exercise that right and petition for nullity for avoidable marriages, the marriage would still be seen as subsisting and continuing. It is a little conceptual. There are also 6 situations where a marriage would be rendered voidable. The first situation is where the marriage has not been consummated owing to the incapacity of either party to consummate it. Do you all know what consummate means? It is a very polite way to say sexual intercourse after marriage ceremony. Now you know what it means. Okay, the consummation has to be ordinary and complete. It cannot be partial and imperfect. So I think you would have some sense of what it refers to. The ground is available to either the husband or the wife. A person can petition on the ground of her own incapacity to consummate, provided that person was not aware of that incapacity at the time of marriage. So I can petition for nullity on this ground if my husband is incapable of consummating, or I can do it on the ground that I can't. But then the condition is that I didn't know about it before I get married. I only find out after I get married. Yes, on the level of evidence, of course. Incapacity can be physiological or psychological, but it has to be permanent and incurable. It is seen as curable if the party refuses to undergo any. Sorry, it is considered incurable if there is a remedial operation or procedure you can do, but it's very dangerous, and the party refuses to do that very dangerous procedure. But it would not be regarded as incurable if the condition can be resolved by a straightforward and risk-free operation. So if there's a way out, but then the operation is very dangerous, then it's reasonable that you refuse to do it, and that means it's incurable. But if very straightforward and easy, then it is curable. The condition is curable. For psychological incapacity, it would require invincible repugnance towards the other spouse. If you merely dislike, mere dislike or rational decision not to commit intercourse is not enough. That's about psychological incapacity. It has to be incapacity, not just that you don't want to. And when there is an arrangement between the parties that they are to marry for companionship, and they both understand that there will be no sexual intercourse during the marriage, then it would bar the party from claiming his incapacity to consummate the marriage. So if you both have that agreement, you both have that understanding that you won't have sex, then you can't rely on this ground of incapacity. Willful refusal is different. It's different from incapacity. You need to show a settled and definite decision to refuse to have sexual intercourse without a just excuse. It is a question of facts and circumstances, and you would need to examine the whole history of the relationship between the parties. You have to know that if you petition for nullity on the ground of consummation with incapacity or willful refusal, then the court has to look into the cause, the reason of non-consummation. And the court has to consider incapacity and willful refusal separately. There are two different things. Although incapacity and willful refusal can arise at the same set of facts, but you need individual findings on these two things and decide whether the decree of nullity is granted on incapacity or willful refusal. I think 2 months ago, I did a FDR. I did a finance case for a party. I represented the husband in that part of the case. He was very angry and both parties were being a little bit unreasonable. I was asking for money from the wife. The husband was asking money from the wife. The wife offered 0. The husband is asking for 10,000. The whole pot, the whole matrimonial assets amounted to some 12,000 Hong Kong dollars. They should have settled, but the husband, at least my client, was not willing. Partially because in their marriage, they're both at the time, as of now, they're both in their 50s. It was a marriage of 3 to 4 years, something like that. They never had sex during their marriage. I think that's one of the great sources of the husband's anger. He was not willing to take a cheap price walking away. He needs to vindicate his anger. So, but he didn't really want to get divorced from the wife. Otherwise, he could have relied on willful refusal for petition of nullity. But then in my case, it was the wife who petitioned for divorce. Okay, I will finish this slide and then we can have a relatively long break. Okay, the third ground for avoidable marriage is where a party did not validly consent, did not really consent, whether in consequence of duress, mistake, unsoundness of mind, or otherwise. Now, duress means threats in a state where you are incapable to give any real or meaningful consent to the marriage. The question is whether the threat or pressure was such to destroy the reality of the consent and overbears the will of the individual. So threat and pressure to the extent that you can't really decide by yourself. Threat can be physical and it can be mental. For mistake, if you want to rely on mistake, it has to be constructed in a very limited, in a strict manner. Mistaken identity of the person can result in the marriage being declared voidable. But errors of judgment or mistake as to one's attributes. For example, if I think I'm marrying a very rich guy or a famous guy and it turned out he's neither rich nor famous, then I can't ask for nullity. Or mistaken as to one's attributes. I know who I'm marrying to as to the identity of the man. So mistake has to be mistaken as to the identity, not just the attributes of a person. So if I think I'm marrying you, but then in fact I'm marrying him, then perhaps you can rely on mistake. A person, when he or she is married, is under the influence of alcohol and drugs, may be successful in petitioning for nullity under mistake or unsound mind. And also when you have mental incapacity, if you are unable to understand the nature of the marriage and the duties and responsibilities that a marriage creates, then you might also be able to petition on this ground of unsound mind or otherwise. And in fact, when you rely on mental incapacity, it can very much overlap with 4. But 4, of course, it has to strictly comply with the meaning of the mental health ordinance. It is voidable if at the time of the marriage, a party was suffering from a mental disorder as within the bound of the mental health ordinance, to such an extent that you are unfit for marriage. So under Section 2 of the Mental Health Ordinance, mental disorder can include mental illness, strictly in the medical sense, or it can be a state of arrested or incomplete development of mind, which amounts to a significant impairment of intelligence and social functioning, which is associated with abnormally aggressive or seriously irresponsible conduct on the part of the person concerned. It can be a psychopathical disorder, or it can be any other disorder or disability of mind, which does not necessarily amount to mental handicap. So the easiest way is that you actually clinically you're diagnosed with a mental disorder, but it is also quite wide in the sense that if you can have insufficient medical evidence to show that you're suffering, you're suffering mental incapacity to the extent that you're unfit for marriage, then you can also petition for nullity on this ground. 5 is when, at the time of marriage, and the respondent was suffering from venereal disease, sexual transmitted disease, in a communicable form. For number 5, you can only rely on it if you discover this problem after the marriage. If you knew about it before the marriage, you go ahead. You can't rely on this ground. And that is the same for for number 6. A marriage is voidable if at the time of the marriage the respondent was pregnant by some other person other than the petitioner, provided that you only find out about it not until the marriage, after the marriage. So by comparison, these factors that would render a marriage voidable would involve some sort of physical or mental incapacity, whereas for the requirements for a marriage to be void ab initio concern mostly what I would call as neutral factors, such as whether you're 16, whether it is a man or woman. I don't know if it helps with your memorization if I categorize these two types separately. Okay, there's one slide for restriction. Do you want to push through for now? And then we take a break. The first restriction is that the court can deny a decree of nullity if the respondent can prove that the petitioner knew that the marriage could have been avoided, but acted in such a way that led the respondent to believe that he would not seek to do so, and it would be unjust to the respondent to grant such a decree. So if the behavior of the petitioner has reasonably led the respondent to believe that the petitioner wouldn't petition for nullity, but she did. That's what the first part means. So if I've acted such a way that you don't think that I will petition for nullity, but then in the end I do, and then in those particular circumstances, it would be unfair to you if a decree of nullity is granted, then the court may refuse to grant such a decree of nullity. And also, the second restriction for nullity is this: the application must be made within 3 years after the date of marriage, except with consummation, the incapacity or the willful refusal. For the other 4 grounds, it has to be made within 3 years. It is an absolute bar of 3 years. If the time of 3 years has lapsed, you can only consider a divorce. Okay. Sorry, it's a little bit technical. I think we can have do you want 20 minutes? Or we can do longer if you want. Too long? Because the remaining part is actually really short. Because it's on separation and maintenance, and I really don't see any practical significance of talking about it at all. But legally it's available, you should know about it. So I will cover it in a really brief manner. Okay. Do you want to do 20 or 15? 15? Yeah, sure. Okay. Okay, I'll see you in 15 minutes. Thank you.